All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining us for the first time, I will hope that you will make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney here in New York whose legal practice focuses entirely on cannabis. If you'd like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or at my email address, which you can see at the bottom of the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of them from a list of questions that I've gotten in previous Ask Me Anything sessions, and the other half from questions which you post in the comments here today. So, if you'd like to ask a question, now is the time to do it. I do have a disclaimer before we get started, and that is that I am an attorney, but I am not your attorney, at least not yet. I did notice that there are a few of my clients in the event today. So, for those of you that are already my clients, don't worry. You are still my clients, and I am still your attorney. But for the rest of you, I am not your attorney, and today's event is not legal advice. It does not create an attorney client relationship, and it is not a solicitation to offer legal advice. And so, with that, let's get started with some of the questions. And we're going to go first to a few of the questions which came in via the comments. The first one is a fairly popular, fairly common question, and I may just start doing an update along these lines each week. But the question is, where does New York currently stand on getting the dispensary licenses? I went to a cannabis festival in Syracuse on Saturday, and no one there was attempting to get a license because there were so many restrictions. The question asker notes that women, minorities, and formerly convicted cannabis people who apply will be granted a license first. So generally the questioner wants to know how far along is the state and when can these other enterprises apply for a cannabis license. So generally right now in the state of New York, we only have one of the adult use cannabis licenses for which there has been an application promulgated and for which the state has actually issued licenses. And that license is the conditional cultivator license. The folks that applied for that license were growers in the state's hemp program for a number of years before the state made the application available for the conditional cultivation license. And it was a fairly easy process once the state decided to spool up that conditional cultivation license. It was a law that was passed by the legislature, and that means that nothing else was needed to be done there. There wasn't a requirement of a 60-day or an additional 45-day public comment period. The Cannabis Control Board was simply able to spool up the application, take applications for that conditional cultivation license, and issue the license. And I believe we are somewhere in the mid hundreds. I believe last week we were at about 162, but somewhere in that neighborhood, 160, 170 conditional cultivation licenses have been issued. Those farmers now have seed in the ground, and they are currently growing what will be the first adult use cannabis crop in the state of New York. That harvest will occur later this year, mostly in October, maybe a little bit in late November. And when the initial conditional adult use retail dispensaries open, this will be the crop that is available for them to sell. Now, when the legislature passed that conditional cultivation license, they also passed a conditional processor license. However, the Cannabis Control Board at this point has not made the application available for that conditional cultivation license. My assessment is that they will probably do that in the next month or so, but so far they have not made those conditional processor licenses available. Now, there is an additional conditional license that will be available hopefully soon. That is the conditional adult use retail dispensary license. Since that was promulgated as a proposed regulation by the Cannabis Control Board, there does need to be the standard regulatory review process. There was an initial 60-day public comment window that ended on May 31st. We are now waiting to see whether or not the Cannabis Control Board wants to make changes to that proposed regulation. And if they do, there will need to be an additional 45-day revised rulemaking period. However, if they don't, they could spool up that application very quickly. So that means that either later this month or perhaps by the end of the summer, depending on whether or not the Cannabis Control Board wants to make changes, we will see an application available for the conditional adult use retail dispensary license. That is the license that will only be available to the justice-involved individuals that were convicted of cannabis crimes here in the state of New York prior to March 31st, 2021, and who also can demonstrate ownership of a business that was profitable for at least 2 years and at least 10% ownership of said business. Now, as you all know, there are also the 9 standard cannabis licenses, which are called for in MRTA. And my guess is that the Cannabis Control Board will make available the initial regulations for those 9 licenses sometime soon. I'm certainly hoping that we see those within the next month or so, and certainly before the end of the summer. If the Cannabis Control Board does that, there is still a path for those regulations to become viable before the end of this year, for that application to become available for those licenses and for those businesses to begin opening next year, early next year ideally. But the longer that the Cannabis Control Board takes to make those regulations available, obviously the further out the date will be pushed for us to be able to get an application up and running and applications in the works for those licenses. All right, I think that, again, answers that question of where the state currently is in the licensing process. Let's move on to one other question that I got early in the comments from attendees to today's event. And the next one is, will siblings be considered as close family members for social equity applicants to be eligible for the first dispensary licenses? So the big picture answer to that question is no. And I will unpack that answer a little bit more in just a minute. I do want to make sure that we are all differentiating between the very special subset of applicants that will be able to apply for the conditional adult use retail dispensary licenses. Those are what we are calling the justice-involved individuals, and that is a very specific subset of social and economic equity applicants. So again, those that are going to be able to apply for those very first dispensary licenses, those that will have to set up shop in the DASNY spaces, as I'm calling them, that is a very, very specific and very narrow subset of social and economic equity applicants. In fact, a lot of the other requirements to apply as a social and economic equity applicant do not apply to those individuals, the justice-involved individuals that would be applying for those initial conditional retail dispensary licenses. Again, the only requirements for that are that you were convicted of a cannabis offense here in the state of New York prior to March 31st, 2021, and that you can show that you were at least a 10% owner of a business that was profitable for 2 years. Those are the only requirements for the justice-involved individuals. For the normal social and economic equity applicants who will be able to apply for the standard 9 licenses that, excuse me, MARTA calls for. Those are minority-owned business, woman-owned business, distressed farmer, service-disabled veteran, and those who live in communities that were disproportionately affected by cannabis enforcement. Those are the 5 classes of individuals that meet the qualification to be a social and economic equity applicant, and they will be able to apply for the 9 standard licenses that will be coming later this year or ideally early next year. Now, back to the original question about whether or not siblings are considered close family members for those first conditional adult use dispensary licenses. I do just want to read for you the exact language that is in the proposed regulation. It is very, very similar to the language that you see over in MRTA as far as who can apply for the conditional adult use retail dispensary licenses. Over in MRTA, this is in the specific subset of folks that will get additional consideration. Again, folks that will be in communities disproportionately affected by cannabis and who have an income below 80% of the threshold within that area, and who were convicted of a cannabis offense. Again, this is an and joinder, not an or joinder. I've talked to a lot of folks that believe it's or for those things, one of them, or another one, or another one. It is indeed an and joinder. And you see the same language about which family members can qualify under that particular element. And just to read it for you, an eligible applicant could have, in addition to being the person that was arrested and convicted for the conditional adult use retail dispensary license, it could also be an individual that had a parent, legal guardian, child, spouse, or dependent who was convicted of that cannabis offense. So, parent, legal guardian, child, spouse, or dependent, or someone who themselves is a dependent of an individual that was convicted of the cannabis offense. So it does not list siblings in that. It is entirely possible that the Cannabis Control Board may make modifications to their regulation. And again, that conditional adult use retail dispensary license is a regulation that is proposed by the Cannabis Control Board, not a law that was passed by the legislature. So it is entirely possible that they will add siblings at a later date. But as the regulation is currently drafted, siblings are not included in the list. The individuals that could apply, and again, this is a right of that individual. The convicted individual does not have to be involved in the business or apply. These are individuals that, because they have a special relationship to the justice-involved individual, they can also apply. And again, that list is parent, legal guardian, child, spouse, or dependent, the person that was convicted, or the applicant can also be a dependent of the individual that was convicted. So that is the list, and it does not appear that at least as currently drafted, siblings will be able to participate or apply. They will be able to participate if they participate with someone that does qualify that applies, but they themselves could not apply. All right. Let's go to some questions that just came in now. Can you give some thoughts on how the New York cannabis supply chain will be able to deal with cash, banking, and financial services? So, as many people are usually familiar with, cannabis does tend to be a mostly cash business. I have talked with several card processors that have capabilities to allow the processing of debit cards, but certainly not the processing of credit cards. Visa and MasterCard are just simply not allowing that, and probably will not allow it until we see federal legalization, which may not happen for quite some time. As far as financial services and banking, there are now a number of banks that will allow banking of cannabis businesses. Those include both smaller banks and other financial institutions, including credit unions, as well as a few what I might call larger banks that are now getting into the business and actually allowing cannabis businesses to be directly banked with them. There are also various service providers that allow what we call an overlay of smaller banks. Now, these service providers are doing all of the know your customer and anti-money laundering work that the smaller banks may not be able to do. And they are also providing an online banking experience, which is much more robust than what the smaller banks may be able to do. So these financial services entities are simply creating portals for the online banking and are going to do all of that KYC and AML work that needs to be done. But you will have your funds directly on deposit with banks. So you will get all of the protections that you would normally see through those banks. And again, direct banking with those banking institutions. So I think you will only see more and more of that as we go forward. But again, at the actual retail establishments and other businesses that are conducting business, it does appear that there is a gateway to do some debit card transactions, though no credit card transactions. But it does appear that the majority of your transactions in this line of work will still be uh, cash. And that does mean that these organizations are going to need to have lots of cash management services that include safes and other ways to protect the cash on site. And then, of course, armored trucks or other cash collection businesses that will be able to collect your cash on a regular basis and take that cash to the financial services entities that you are working with and have that cash then go on deposit with them such that you are not keeping uh, significant amounts of cash on site at your cannabis businesses, which is obviously creates a real risk for theft or other types of illegal activity as far as what happens to that cash. All right, let's go to another couple questions that came in online today. Is it clear that adult use processor licensees will be able to sell directly to dispensaries? It is not clear that adult use processor licensees will be able to sell directly to dispensaries. And in fact, if you look at MRTA, processors will not be able to sell directly to dispensaries unless they have gotten an additional distributor license. And that distributor license will only be good or valid for whatever the processor processes themselves. So a processor would not be able to purchase goods that were processed by other processors and then through their distribution license sell them to dispensaries. So the only way a processor can sell to a dispensary is by getting that one additional distribution license for their own processed products. And again, generally in the cannabis industry in New York, the entity that will be able to sell directly to the dispensaries is going to be the distributor, entities that have gotten the distribution license. And again, processor can get one distribution license of their own cannabis products. And additionally, a cultivator would be able to get one processing license and one distributor license. Again, both of those only for products which the cultivator has grown. So again, only their own cannabis. So that is the way the wholesale sales, try saying that 3 times quickly, that wholesale sales will be made within the New York cannabis market. It will be of distributors or people that have a distribution license of their own cannabis to the retailers. And again, that will likely include, or as the law is drafted right now, will include micro businesses. They will be able to distribute their own adult use cannabis. All right, let's go to a few other questions from our backlog. How much cannabis can I legally possess? And it's a very good question, although obviously many of the criminal issues related to cannabis in New York have been eliminated. There are certainly still fines in place if you are possessing too much cannabis. So how much can you legally possess? So you are allowed to legally possess 3 ounces of flour, up to 3 ounces of flour, up to 24 grams of concentrate. So that would be 24 grams of shatter, 24 grams of live resin, any of these types of concentrates you'll be able to possess. And in the draft regulation for the medical home grow, it does indicate that within your home, you would be able to possess 5 pounds of cannabis that you grew through your medical home grow. And my guess is that once we see the adult use home grow provisions, which will almost certainly be 6 plants, typically three flowering and 3 in their growth phase, a maximum of 12 plants, regardless of how many members you have in your family. So it's 6 plants per family member with a maximum of 12. So even if you have 10 people in your family, only 12 plants. And my guess is that you will see a similar level of possession within the home, whether or not it's the same 5 pounds that that the Cannabis Control Board has proposed for medical growers. We'll wait and see, but I am quite certain that they will allow a larger threshold within your home of cannabis that you've grown versus the standard that you're allowed to have on your person anywhere, which is 3 ounces of flower or 24 grams of concentrate. All right, let's go to another question from the backlog, and that is, do you have an educated guess as to the time period that only provisional licensees will be operating? I have heard varying opinions from 6 months to 2 years. And just to be very careful here, the term of art here in New York is conditional licensees. I do think you could say it's roughly the same as a provisional licensee. But again, here in New York, the term of art is conditional licensee. And it does appear that, or I guess at least I would say my hope is that it's the lower threshold of the number that you suggested. That there will only be conditional licensees here in New York for the next 4 to 6 months. Again, my hope is that the Cannabis Control Board will get the conditional adult use retail dispensary license up and running as far as the license application process, either at the end of this month if they don't want to make changes to the regulations, or by the end of the summer if they do want to make changes to the regulations. Once we get to the end of the summer, they could very quickly make that application available. Their goal is to get the conditional licenses up and running by the end of this year. We then will need the rest of the regulations for the standard 9 licenses. Those will have to go through the same regulatory process as the conditional adult use retail dispensary license needed to go through. So that's an initial 60-day window when they take comments, a time period of a couple of weeks, maybe a month, maybe more. We'll see when they decide if they want to make changes based on the feedback they get. And if they do, an additional 45-day revised rulemaking period. So as you can see, that's a minimum of 105 days plus however long it takes them to make the changes, assuming they do make changes. If we get the regulations, say by the end of July, I'm hoping sooner, but let's say end of July, 3 months, a little more, 4 months from then would get you to roughly the end of the year. So it would then be possible for the Cannabis Control Board to start taking applications for the 9 standard licenses, either at the end of this year or beginning of next year. And so if that all is possible, I do think you could see we hit that 6-month window of when you will start to see non-conditional licenses being issued and available. My hope is that at the latest, we start seeing that happen in Q1 of next year. That will require pretty much everything going right as far as the process, but it's not entirely impossible. All right, let's go to a couple more questions that are coming in today online. Any indication that dispensaries will be allowed to deliver? At this point, there is no firm indication. If you look in MRTA, I do not believe that a delivery license is one that is specifically called out in the dispensary list as a license that dispensary owners cannot have. I do think that was perhaps an oversight on the Cannabis Control Board's part, and they may clean that up in the future regulations. Again, it does not say in the delivery license section that the delivery licensee can't hold some other licenses. So this is just a weird thing where I think some of the verbiage in MRTA perhaps needs to be cleaned up by the legislature at some point, and perhaps by the Cannabis Control Board via regulation. So right now it's really unclear. I do think the most fair way that the Cannabis Control Board could make things happen here would be to allow dispensary owners to have one delivery license, and for delivery licenses holders to be able to hold their own inventory. This is a discussion we had last week about whether or not the delivery license holders can hold their own inventory. I have an email from from the Office of Cannabis Management, where the person that responded said, in fact, delivery licensees will not be able to hold their own inventory. Now, I certainly respect the individual that responded. That must be indicating the way the discussion is going in the Cannabis Control Board and the Office of Cannabis Management. My hope is that they reconsider going in that direction. My thought is that the fairest way to do it is to let dispensaries have one delivery license and let the delivery license holders not have a retail store, but be able to hold their own inventory to then do delivery. It is clear from the delivery license language that a delivery license holder can only have 25 full-time equivalents doing delivery licensing, doing delivery license delivery. So it does seem fair. Let the dispensaries have 25 FTEs doing delivery. Let the delivery license holders have 25 FTEs doing delivery, and let them hold their own inventory. All right, I think we're going to do one or more questions, and then we're going to wrap it up for the day. Can you have a liquor license and a cannabis license? So I want to be very clear how we answer this question. Yes, you could both hold a liquor license and a cannabis license, but you could not have the business for those licenses in the same space. So if you want to have, let's say, a cannabis dispensary license and you also got a liquor license for a bar, it does seem that you could have that liquor license for the bar and you could have that cannabis license for a retail dispensary, but you could not serve alcohol in your cannabis dispensary, and you could not sell cannabis in your bar, or if you want to think of it, your alcohol dispensary or your alcohol on-site consumption lounge. So it does seem clear that if you have a liquor license, you can apply for a cannabis license, but you will not be able to have those licensed entities take residence within the same footprint, within the same physical space. So that is really a key distinction as far as how that is going to work. Let's see. Going to do one more question from the questions that came in today. Are conditional cultivators under the conditional adult use cultivator license required to register with their county they are growing in and to remain in good standing, similar to those with hemp license? So the conditional cultivators are only able to have that license due to their participation in the hemp program. They do not have the notification requirement that retail dispensaries have or on-site consumption lounges have, where you had to notify or will have to notify the regulatory body, and here in New York City, that is going to be the community boards, as to the fact that you're going to open such an establishment. Again, the community boards and the areas upstate for the dispensaries and the on-site consumption lounges do not have an up or down vote. They're simply able to put in a letter with the application that is being put into the Cannabis Control Board, who is the entity that will ultimately have that up or down vote as to whether or not they're able to get that license. Absolutely, I do think it is a requirement that you remain in good standing. For any other licenses that you've had previously, that was a requirement for you to even be able to apply for the license. So certainly one of the methodologies that the Cannabis Control Board and the OCM may look at for why they might want to revoke your license is whether or not you're no longer in good standing for another license that you needed to have in order to even be eligible for that license in the first place. All right. We're right now at 4:50, so we've done our half hour for today. I do want to give big thanks to everyone that participated in today's Ask Me Anything. Just as a reminder, we do it every Wednesday at 4:20 New York City time, so would welcome everybody to come back and participate again next Wednesday. Just a reminder, if you're not currently a connection of mine on LinkedIn, by all means, reach out to me and ask for a connection on LinkedIn. LinkedIn does only allow you to do 100 connection requests per week. I usually have used those up by Monday or Tuesday every week and have already done so this week. So by all means, reach out to me and ask for a connection. I'll be happy to accept it. And as I say every week, while I know we're all very excited that there's soon to be a legal cannabis industry here in New York, the most important thing that happened in the cannabis law is the fact that we're now expunging the records of everyone that was convicted of most cannabis offenses in the state of New York. So those folks are no longer going to have to check the yes box when they apply for jobs or when they apply for housing. Additionally, and this is very important, a state which profits from an activity for which it incarcerates people is engaging in a crime against humanity. The state of New Jersey has a big problem about this. The state of New Jersey is making in millions and millions in tax dollars every month selling cannabis while they are incarcerating nonviolent cannabis offenders. New York can and must do better. New York is making a little in tax dollars from the medical cannabis that's happening now, and New York is going to make hundreds of millions, if not billions of dollars over the next several years from the adult use cannabis market. New York cannot be incarcerating nonviolent cannabis offenders if that is happening in the state. They all must come home, either through pardoning them, which is ideal because that means they no longer have that on their record in any way, commuting the sentence if that's the way we have to go and do it. And you're going to be hearing much more from me about this in the coming weeks and months about how we're going to go forth and get all of the nonviolent cannabis offenders out of jail. If the state is going to make money from the sale of cannabis, we cannot have nonviolent cannabis offenders incarcerated. Thank you very much for attending, and we'll see you next week. Have a good one, everybody.